Good afternoon, everyone. So, I hope all of you are doing well and also preparing well for your exams. Today's case is Devilal versus the state of Madhya Pradesh. This is yet another criminal law judgment summary, which we are going to go through, which we are going to learn and read about today. This was the criminal appeal number 1989 of 2007. Okay, and one of the important judgments with regard to the decision of the age of an accused when he is supposed to be a juvenile. Okay, the important sections involved in the case are section 34 of the Indian Penal Code, section 302, section 342, and section 20. Section 342 of the IPC, like 34, 342, and 302 of the IPC, and section 20 of the Juvenile Justice Care and Protection of Children Act 2000. Okay, this is important. Okay, there are plenty of cases, plethora of cases there relating to section 302, section 342, and section 30, read with section 34 of the IPC. But what makes this case distinct is its relation with one of the accused in the case, who happened to be juvenile at the time when the proceedings of the case started, and later on when Juvenile Justice Care and Protection of Children Act 2000 was passed, the age of juvenile was raised from 16 to 18. So that is the question of law. That was the question of law to be decided by the Supreme Court, that if any accused happens to be a juvenile at the time when he committed the offense and the proceedings against him have already begun, okay, while treating him as an adult, because at the time when he committed that offense, Juvenile Justice Act 1986 was already in force, which prescribed 16 as the age of juveniles, 16 years as the age of juveniles, while the accused happened to be more than 16 years of age but less than 18 years of age. At the time when proceedings were going on and such accused was being treated as an adult in the normal conventional court, okay, then Juvenile Justice Care and Protection of Children Act 2000 was passed and the age of juvenile was raised from 16 to 18. So the question that arose in this case was how the juvenility of the accused has to be decided. Does he needs to be treated as a juvenile or as an adult? So the question was decided by the Supreme Court. Okay, this is a criminal law case which involves section 302. So it's a serious issue. Section 342, wrongful confinement, it's punishment for wrongful confinement. Section 302, it's punishment for murder. Okay, read with section 34 of the IPC. Okay, so what is section 34 of the IPC? What is section 34 of the IPC? When a criminal act is done by several persons in furtherance of the common intention of all, each of such persons is liable for that act in the same manner as if it were done by him alone. So when a criminal act is done by several persons in furtherance of the common intention, when a criminal act is done by several persons in furtherance of the common intention, it shall be deemed as if that act was done by him alone. Each of such persons shall be liable in a manner that such act was done by such person alone. Okay, So that is section 34, that establishes the rule of common intention. That if 4 or 5 people are, for example, involved in a case or involved in a crime, there shall be deemed a common intention and there shall be furtherance of common intention. Okay. Furtherance, and in the furtherance of the common intention, they have committed the crime. And each of that person shall be liable in a manner as if the crime were done by him alone. Okay. So this is one of the cases, because the case is not all about the juvenility of an accused, of one of the accused. It is also about section 302. But what we are going to stick to or adhere to or confine ourselves to will be the question of juvenility of one of the accused in this case. We are not going to discuss if the rest of the accused in this case were either guilty of the offenses under section 302 and 342 of the IPC or not. Because right now you can get plethora of cases on these kinds of sections and you can read any of the cases you like. But the question that was supposed to be decided, what has made this case distinct from others, is the question of juvenility of one of the accused in this case. Okay, so Devilal versus the state of Madhya Pradesh is a case which came before the Supreme Court in a form of a criminal appeal number 1989 of 2007, and the bench was presided over by Justice U.U. Lalit and Justice K.M. Joseph, one of the most well-known judges of the Supreme Court. Okay, date of judgment is 25th of February 2021. Okay, now in this case, the court considered to what extent could the benefit under the Juvenile Justice Act be extended, where the offender was above 16 years and less than 18 years of age on the day the offense was committed. The question was that when he committed the crime, he was above 16 years, he was above 16 years of age, but he was less than 18 years, like he was 16 years, 11 months and something. Okay. So he was adult according to Juvenile Justice Act 1986. This accused was an adult. He was not a juvenile. But when the proceedings started and the proceedings were going on in full swing, then the Juvenile Justice Care and Protection of Children Act 2000 came, which raised the age of juveniles from 16 to 18 years. The question was that the accused in this case, who was being treated as an adult, are his proceedings going to be continued in the same manner while treating him as an adult, or his case has to be transferred to the Juvenile Justice Board? Okay, so in this case, the court considered to what extent could the benefit under the Juvenile Justice Act be extended where the offender was above 16 years and less than 18 years of age on the day the offense was committed. Okay, what benefit such accused can have when such changes takes place when such modulations takes place or such amendments takes place in such laws. The court held that in such a case, even if the accused were guilty, the matter must be remitted to the Jurisdictional Juvenile Justice Board, because that is what section 20 had already stated. Section 20 of the Juvenile Justice Care and Protection of Children Act 2000. However, if we talk about the recent changes made in the Juvenile Justice Care and Protection of Children Act 2000, we would come across a recent amendment which was made after the Nirbhaya rape case in Delhi. You must be knowing, and every one of us knows what happened with Nirbhaya in Delhi. On the night of 12th December 2016, what happened? And one of the accused in that case was also a juvenile who was a little bit younger than 18 years, like he was about to complete his 18 years But before he could complete his 18 years, he committed the rape of Nirbhaya. And he was one of the most hostile persons, one of the most, heinous perpetrators amongst all. So the question was that in heinous offenses like this one, does the age needs to be reduced from 18 to 16? And is it necessary to treat such juveniles as adults and not juveniles? So a recent amendment was also made after the post Nirbhaya case. The amendments was, while the entire criminal law was being fine-tuned, Juvenile Justice Care and Protection of Children Act 2000 was also amended, and the age was again reduced to 16 years, but only in cases of heinous offenses. What is heinous and what is non-heinous has to be decided by the circumstances, facts and circumstances of each case, which will finally be looked upon by the Supreme Court or the courts. Okay. So the facts of the case. Let us read the facts of the case. In FIR number 212 of 1998, but one thing more, I guess everything is clear. Everything is clear to you up till here. Any question? Any doubt? I hope you are getting what are we going to discuss in this case, probably. Okay, it's clear to you, I guess. Okay. Thank you. So let's start reading the facts of the case. In FIR number 212 of 1998, filed at 11:10 p.m. on July 19, 1998, Ganesh Ram stated that on July 14, 1998, while walking to his house, he saw Devilal armed with a kulhari, his son armed with a talwar, and Amritlal armed with a lathi in front of Devilal's residence. So they had some enmity, like a very old enmity between them, and that was simply being vented out by these people. So what happened and from where it started is not our concern right now. So while walking to his house, he saw Devilal armed with a kulhari, his son armed with a talwar, and Amritlal armed with a lathi in front of Devilal's residence. Ganesh Ram was abused. Now this complainant, this FIR was launched by Ganesh Ram because he was the victim of the crime. Okay? He was the victim of the crime. He was walking to his house, but he saw on the way to his house, he saw Devilal, his son, and one other person named Amritlal armed with kulhari, talwar, and a lathi respectively in front of Devilal's residence. Like these people were standing in front of their own house. Ganesh Ram was abused by Devilal, who referred to him as a chamar and claimed that chamars had advanced too far. Like this is a very offensive thing to call somebody a chamar, because this is not an abuse, this is not a cuss word. This is simply looking down upon a caste with severe disapprobation. And this is absolutely punishable because this leaves a person who belongs to a particular caste as offended. So this is highly punishable and this is offensive. And this is highly unbecoming for a civilized society. So Ganesh Ram was abused by Devilal, who referred to him as a chamar and claimed that chamars had advanced too far. Then Devilal and his son Amritlal beat Ganesh Ram with their kulhari, talwar and lathis, fractured his right hand, cut his right calf, kicked him in the face below both his eyes, and the swelling was visible at the time of the report. Ganesh Ram screamed for help, and his mother Gattu Bai, wife Sajan Bai, and sister-in-law Saman Bai came out to protect him. While guarding Ganesh Ram, Saman Bai was struck in the elbow by Devilal's lathi. Ganesh Ram's sister-in-law and Satyanarayan then loaded him into a tractor and drove him to the police station to file out an FIR. I hope the facts of the case are very clear to you because they are so clearly and straightforwardly written. Okay. Ganesh Ram is the complainant. He was walking to his house. On the way to his house, he saw Devilal and his two sons standing in front of their own house, Devilal's house, with the lathi, talwar and what? Kulhari. And they started abusing him. They started beating him. Okay. Then Ganesh Ram was, defended, he was helped out by his mother, wife and sister-in-law. Okay, then they took him to the police station to file out an FIR. Ganesh Ram died at 1 a.m. While succumbing to his injuries, he finally died at 1 a.m. while being treated at Mandsaur District Hospital while Kothari was completing the legalities. Okay. By its judgment and order dated 1/5/1998, like 1st May 1995, the trial court found that the FIR recorded at the instance of the deceased could be relied upon as a dying declaration. Sajan Bai, Saman Bai and Lakshmi Narayan, as well as the recoveries at the instances of accused Devilal, Gokul and Amrit Ram, proved the prosecution's case. The prosecution had proved the offence under section 302 read with section 34 IPC according to the trial court. So I have a question. Who filed the complaint? Baat is asking who filed the complaint. Ganesh Ram filed the complaint. See, it's written here. It's written here. Ganesh Ram's sister-in-law and Satyanarayan then loaded him into a tractor and drove him to the police station to file an FIR. So who filed the FIR? Ganesh Ram himself, because he was beaten up badly by Devilal and his two sons. Okay, so Ganesh Ram's sister-in-law and Satyanarayan loaded Ganesh Ram into a tractor and drove him to the police station to file an FIR. He was beaten up badly now, so he was the victim. He himself filed the FIR. He died later on. Please read the facts very carefully. What I am saying is he first filed an FIR, then he went to the hospital and he died at 1 a.m. Ganesh Ram died at 1 a.m. Firstly, he was taken to the police station to file an FIR and later on he went to the hospital. Okay, so at least he was in a position at the time when he was taken to the police station to get the FIR registered. So Ganesh Ram died at 1 a.m. and that's what the paragraphs are talking about, that the prosecution said that the FIR was registered himself by the Ganesh Ram himself. By Ganesh Ram himself. So this should be taken as a dying declaration. Okay. This can be taken as a dying declaration. That's what we are talking about. Okay. By its judgment and order dated 1st May 1998, wait a minute, now you are confusing me. So what? July 14 ko hua. FIR was filed on July 19, okay, and he died afterwards. There's no rocket science involved in understanding this. So what? The incident happened on July 14. FIR was filed in on July 19, and then afterwards he died afterwards. So this could be taken as dying declaration. While succumbing to his injuries, like he might have developed some septic infection in his body, or while anything would have happened, like he succumbed to his injuries. So by its judgment, an order dated 1st May 1998, the trial court found that the FIR recorded the instance of the deceased could be relied upon as a dying declaration. The trial court found that that since the FIR was recorded at the instance of the deceased, and this could be taken as a dying declaration. You must have read dying declaration. How many of you do not have an idea about dying declaration? Tell me. What is dying declaration? What is dying declaration? Why do I have to share this PDF document beforehand with you? If you do not go through the documents in advance, and if you do not try to know that the case is about what, that is why I guess you simply sit barehanded. You don't have your bare text and bare acts with you. I don't know why. At least you should go through the PDF docs, find out the cases and the sections involved in the case, and at least sit with your bare acts. Okay. So Anakha is also making a very good point. Very good point. Date of filing of FIR may not be the same as the date of the complaint. That's also one of the rightly observed thing, Anakha. Very good. Okay. It's not necessary that the FIR can be registered on the same date when the complaint was made. No issues. Okay. Okay. That's a very good observation, Anaka. Very well done. So dying declaration is, everyone is telling me correctly, section 32 of the Indian Evidence Act. So may Shankita Prablin Baat Jazbat Uttam is also correct. Declaration made by a person who is under apprehension of death. Okay. Who is dead or cannot be found is relevant when it relates to the cause of death. Okay, I'm reading this section. Cases in which statements of relevant fact by a person who is dead or cannot be found, etc. is relevant. Statements written or verbal of relevant facts made by a person who is dead or who cannot be found, or who has become incapable of giving evidence, or whose attendance cannot be procured without an amount of delay of expense, which under the circumstances of the case appears to the court unreasonable, are themselves relevant facts in the following cases. 1. When it relates to the cause of death, when the statement is made by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death, in cases in which the cause of that person's death comes into question. Such statements are relevant whether the person who made them was or was not at the time when they were made under expectation of death, and whatever may be the nature of the proceeding in which the cause of his death comes into question. Okay, with regard to the cause and circumstances that led to his or her death. Very nice, Anaka. So this is dying declaration. He narrated the whole trail of events, what actually happened to the police. He filed a complaint, he made a complaint to the police. Later on, the FIR was registered at the instance. The question raised by the trial court was, the observation was that the trial court said, since the FIR was recorded at the instance of the deceased, the FIR was the same thing. The complaint made by Ganesh Ram, who died later, was converted into an FIR on a later stage, and that could be taken as a dying declaration. Okay, that can be taken as a dying declaration. So dying declaration is one of the strongest evidences for the prosecution. Okay, one of the strongest evidences for the prosecution. Okay, now the question is, all the testimonies of the Sajjan Bai, Saman Bai and Lakshmi Narayan were also recorded. Okay, and Lakshmi Bai were also recorded. Can you please explain me? Listen to me very carefully. I am raising a question here. Can you explain me that the testimonies of Sajjan Bai, Saman Bai and Lakshmi Narayan are relevant under which provision of the Indian Evidence Act? Are relevant under which provision of the Indian Evidence Act? My question is that the trial court took cognizance of the statements of Sajjan Bai, Saman Bai and Lakshmi Narayan, and their testimonies were relied fully upon by the trial court to make out the prosecution's case. Now tell me, the testimonies of Sajjan Bai, Saman Bai and Lakshmi Narayan were relevant as a strong evidences under which provision of the Indian Evidence Act? Tell me. What is there for section 25 to 30? What is there in 25 to 30? No. It's very simple. Very simple. Listen to me very carefully. Now I'm explaining you. Ganesh Ram was being beaten up. When he shouted and screamed for help, who came? His mother, his wife, his sister-in-law and Lakshmi Narayan, they came. They came and helped him. Okay, like they saw him being beaten up. So, facts are relevant which form part of the same transactions, and that is under section 6 of the Indian Evidence Act. Relevancy of facts forming part of same transaction, which is also known as Res Gesta. So Sajjan Bai's, Saman Bai and Lakshmi Narayan's testimony was important because their testimonies formed part of the same transaction under section 6 of the Indian Evidence Act. If you read illustration A of section 6, it is exactly like, it's very similar to this case. A is accused of the murder of B by beating him. Whatever was said or done by A or B or the bystanders at the beating, or so shortly before or after it, as to form part of the same transaction, is a relevant fact. This is known as the principle of Res Gesta, R-E-S, Res Gesta, G-E-S-T-A-E. Okay, Res Gesta. Facts forming part of the same transaction. So by its judgment and order dated 1st May 1998, the trial court found that the FIR recorded at the instance of the deceased could be relied upon as a dying declaration. Sajjan Bai, Saman Bai and Lakshmi Narayan, as well as the recoveries at the instances of accused Devilal, Gokul and Amrit Ram, proved the prosecution's case. Okay. Proved the prosecution's case. Like the trial court was of the opinion that the prosecution's case is clearly made out. There is a strong case from the side of the prosecution. The prosecution had proved the offense under section 302 read with section 34 of the IPC according to the trial court. Okay. Ananya Das is still asking it's 60. It's not 60. I'm telling you it's section 6. Okay. The prosecution had proved the offense under section 302 read with section 34 IPC according to the trial court. So the trial court was of the opinion that the prosecution has proved its case under section 302 read with section 34 of the IPC. Okay. The case against Gattu Bai, on the other hand, was deemed to be unproven, and it was also determined that none of the defendants could be charged with crimes punishable under the SC/ST Act. Okay. The Juvenile Justice Act of 1986 was in effect when the offense was committed in 1998 and stated that anyone under the age of 16 was deemed a juvenile. So I told you in the beginning of the lecture that the Juvenile Justice Act 1986 was already in effect, which prescribed the age for juveniles as 16 years, and when the offense was committed in 1998, this Juvenile Justice Act 1986 was already in force and 16 years was taken as the age for the juveniles. So Amrit Ram, Devilal's second son, was 16 years, 11 months and 26 days old at the time the crime was committed. So he committed the crime as and when he was 16 years, 11 months and 26 days old. Okay, already. So like according to the Juvenile Justice Act of 1986, he was not a juvenile. He was an adult. He was not a juvenile. He was an adult. Juvenile Justice Act of 1986 was already in force in 1998 when the offense was committed, according to which the age for the juveniles was 16 years. Devilal's second son, Amrit Ram, was 16 years, 11 months and 26 days old at the time when he committed this crime. So his trial was to be done as an adult, not as a juvenile. Okay. As a result, he was plainly not a minor under the Juvenile Justice Act of 1986. However, under the requirements of the Juvenile Justice Care and Protection of Children Act of 2000, this age was raised to 18. Okay. Now, while the proceedings were going on, this Juvenile Justice Care and Protection of Children Act of 2000 came, which raised the age for juveniles from 16 years to 18 years. The Supreme Court had ordered the Sessions Court to investigate and report on the matter of The Supreme Court had ordered the Sessions Court to investigate and report on the matter of juvenility. Ananya Das is saying I said 5 minutes before you explain. Okay, okay. Actually, there is a there is a delay of 2-3 minutes in the display of the video, I guess. Okay. Okay, Ananya. Okay. There's a display like whatever I am saying is reaching you like 60 after 60 seconds or 70 seconds. So there is a reasonable delay in understanding. Okay. However, under the requirements of the Juvenile Justice Care and Protection of Children Act 2000, this age was raised to 18. The Supreme Court had ordered the Sessions Court to investigate and report on the matter of juvenility. Now, please, you have to tell me if you are encountering any ambiguity either in the facts of the case or in understanding any point of law. Please tell me if there is any doubt. Any question, any doubt up till here? Any question, any doubt up till here? Ankita, you want me to repeat the facts in brief? Ganesh Ram was simply walking back to his house. He saw the three accused standing in front of their house who started beating him. Okay, who started beating him. He was defended by his sister-in-law, his mother, and his wife. He was taken to the police station. He filed a complaint, which was later converted into the FIR when the evidence was found quite strong against the accused. Okay, simple. Yeah, it's as simple as that. When the matter before the trial court found that the FIR was registered at the instance of the deceased, and so it could be taken as a dying declaration. Also, the testimonies of all the people who came to defend the Ganesh Ram were also held to be relevant facts and strong evidences under Section 6 of the Indian Evidence Act as forming part of the same transaction or res gesta. That's it up till now. The question is simple, that one of the accused, Amrit Lal, Devilal's second son, he was 16 years 11 months and 26 days old at the time when he committed the offense. According to the Juvenile Justice Act 1986, which was enforced at the time when he committed this offense, he was not a juvenile, he was not a minor, and he was simply being treated as an adult. But when the proceedings were going on over the years, this Juvenile Justice Care and Protection of Children Act 2000 was passed, which raised the age for juveniles from 16 to 18 years. And the question that arose was whether this case, which is already pending and which is already sub judice, has whether in this case this person called Amrit Lal has to be treated as a juvenile or as an adult. Okay. Somesh is asking, if increasing age from 16 to 18 years for juvenile, then what will be the difference in major and juvenile, as major is someone 18 years? I mean, this is a very technical question that you are asking. I cannot answer this question. I have my own personal opinion in this. Like, any person who attains the age of who comes off the puberty age, simple, has to be treated as an adult. That's my personal opinion. That is my personal opinion. Like, that is my personal view, that anyone who comes of the puberty age has to be treated as an adult, because if he can understand the different nuances and if he can have this intelligence to commit a crime like an adult, he should be treated as an adult. That's it. I don't know if 18 years has to be the age. I mean, a person attains maturity biologically at the age of 14 or 15 years. But according to law, he's being treated as a minor until he attains the age of 18 years. That is what the law is saying. Simply, you cannot determine someone's maturity by simply writing a paper of law. Okay. There must be some differences between 16 and 18. I don't know why this age bar has been created so strictly, because this was being simply violated in the Nirbhaya case also. So what you are asking is a technical question. Anybody, I guess everyone must be having different opinions with regard to this. Okay. And Ananya and Ankita, I want to ask if the facts are clear to you. The facts should be clear to you now, I guess. sections, criminal appeals and case laws in order of mention. Now section 34 of the IPC, what are the provisions which are involved in this? Section 34 IPC, section 302 IPC, section 342 IPC, section 20 of the Juvenile Justice Act 2000. Okay, arguments and decision of the court. The prosecution showed that Devilal and his two sons were guilty under section 302 and 34 of the Indian Penal Code by the decision and order of the trial court 5th January 1999. It's also worth noting that despite the alleged caste-based altercation, the court did not find them guilty of crimes punishable under the SC/ST Act. Okay. Actually, this act is Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. One of the strictest penal laws for punishing the caste-based altercations. If somebody is if somebody is involved in caste-based altercations, or calling somebody or looking down upon the other person with disapprobation only because he belongs to only because he belongs to a particular caste. Okay, this is punishable under the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. A separate judgment found the appellants guilty of violating sections 342 and 34 of the IPC and sentenced them to life in prison and a punishment of rupees 5,000 each. Okay, however, the trial court found them guilty under section 302 and 342 and all the other sections, but it did not find them guilty under the SC/ST Act. Okay. Later, the appellants filed a criminal appeal. Now, the appellants filed a criminal appeal 700 of 1999 at the High Court, requesting that Dr. Kothari's medical evidence be considered. They argued that it was exceedingly unlikely that the deceased Ganesh Ram would have given any statements to the police prior to succumbing to the injuries that led to the filing of the FIR in this case. Now, actually, all these accused, whom the trial court found guilty, they came in an criminal appeal before the High Court, and so they become the appellants. They were now trying to attack the veracity and authenticity of the dying declaration. What did the trial court do? The trial court simply took the FIR as a dying declaration because it was recorded at the instance of the deceased. And dying declaration is one of the strongest evidences prosecution can ever have. So what the first thing they did when they came in the criminal appeal before the High Court is that they started attacking the veracity and authenticity of the dying declaration. Okay. They argued that it was exceedingly unlikely that the deceased Ganesh Ram would have given any statement to the police prior to succumbing to the injuries that led to the filing of the FIR in this case. The High Court rejected the appellant's contentions and thus upheld Devilal's conviction and sentence as well as that of his sons Gokul and Amrit Ram, and dismissed the accused criminal appeal number 700 of 1999. This decision was handed out on September 14, 2006. Okay, the High Court rejected the appellant's contentions. The High Court said no. Dying declaration is a dying declaration, and in every dying declaration, anybody who is about to succumb to his injuries makes a statement about his death, relating to the cause of his death. So it is not unlikely that the deceased Ganesh Ram would not have given any statement to the police prior to succumbing to his injuries. Okay. How could it be unlikely? Dying declaration is every time of this kind only. So the High Court rejected the appellant's contentions and upheld Devilal's conviction and sentence, and as well as that of his sons Gokul and Amrit Ram. Like whatever the trial court held was actually upheld by the High Court. Now what happened? Furthermore, it was claimed that Amrit Ram, Devilal's second son, was a minor at the time the crime was committed. Now this is a question of law that which was raised. It was claimed that Amrit Ram, Devilal's second son, was a minor at the time the crime was committed. The statement of the accused juvenility could be presented for the first time before the court in light of the Hari Ram versus the state of Rajasthan ruling. The sessions judge Neemach was directed by this court to conduct an inquiry into this issue of juvenility by order dated 3rd October 2018, and it was discovered that the accused Amrit Ram was 16 years, 11 months and 26 days old in 1998, and he was found to be a juvenile for the purposes of the Juvenile Justice Act 2000 on the date of the offence. The question was that as and when he committed the crime, he was not a juvenile according to the Juvenile Justice Act 1986. But when the proceedings were going on, he became a juvenile by virtue of Juvenile Justice Act Care and Protection of Children Act 2000, which raised the age from 16 to 18 years. So he needs to be treated as a juvenile and not as an adult. This was the contention of the appellants. Okay. Because the age of juvenility was raised to 18 years by the Juvenile Justice Act of 2000, it was now up for discussion what should be done with the accused juvenility. Like, this was to be mooted upon by the Supreme Court, that if what we have to do with the accused juvenility. Like, he was not a minor according to the previous Juvenile Justice Act of 1986 and at the time when he committed the crime. But by virtue of Juvenile Justice Act 2000, he has become a minor. Now let us see what the Juvenile Justice Act 2000 has to say on cases where the crime was committed earlier than the like before 2000, before the coming of this act. So it was noted that notwithstanding anything in this act, now Section 20 of the Juvenile Justice Act 2000, it simply says, I'm reading here, read this third line. Okay, this third line in this paragraph, notwithstanding anything in this act, all proceedings in respect of a juvenile pending in any court on the date on which this act comes into force, if the court finds that the juvenile has committed an offence, it shall record such finding, and rather than passing any sentence in respect of the juvenile, forward the juvenile to the board, which shall deal with the juvenile in accordance with the Juvenile Justice Act 20. Like this has to be 2002. This is a typo. Don't mind this. Okay. It was noted that notwithstanding anything in this act, all proceedings in respect of a juvenile pending in any court on the date on which this act comes into force, if the court finds that the juvenile has committed an offense, it shall record such finding, and rather than passing any sentence in respect of the juvenile, forward the juvenile to the board, which shall deal with the juvenile in accordance with the Juvenile Justice Act of 2000. Okay? Any doubt? इसका सिंपल सा मतलब ये हुआ that on the coming of this act, all the pending proceedings must be transferred to the Juvenile Justice Board. Simply, if any proceeding is going on against any person who is less than 18 years of age, all those proceedings must be stopped right away, and they must be transferred to the Juvenile Justice Board. That's it. That is what Section 20 of Juvenile Justice Act 2000 has to say on this point. So Jazbaat Tum has not understood. Not understood. You have not understood? Section 20 of Juvenile Justice Act 2000 simply says that any proceeding which is going on against any person who is less than 18 years of age in any court of law has to be stopped right away, and the case must immediately be transferred to the jurisdictional juvenile justice board. Okay, because all those people who were older than 16 years of age and less than 18 years of age, and all such persons who are being tried by the normal conventional courts like an adult, should be stopped, and all these kinds of cases should be transferred to the juvenile justice board. Simple, because all those people have now become juvenile by virtue of Juvenile Justice Act 2000. Para will come from judgment only, from only cases. What are you trying to say, Ankita? Thus, Amrat must be remitted to the jurisdictional juvenile justice board for determining appropriate quantum of fine that should be levied up on him. Okay, like Amrat Lal was finally declared as a juvenile, although he was not a juvenile at the time when he committed the offense, but section 20 of the Juvenile Justice Act 2000 made him juvenile. Okay. So the Supreme Court said that trial court ab iska wo nahi karega, faisla nahi karega. The judgment should be transferred to the proceedings should be transferred to the jurisdictional juvenile justice board for determining appropriate quantum of fine that should be levied up on him. Have you understood? Any question? Ankita, see, we are reading these judgment summaries so that we can sharpen our minds on understanding the different applications of law, because any kind of question can be asked from you. Okay, you can be asked like that on a point of law, Juvenile Justice Act 2000, or on the point of determining the accused juvenility, which of the following cases they relate to the accused, determining the accused juvenility. Okay, so any kind of question can come. Somesh is asking, what is the present age for juvenile? Present age for juveniles in general is 18 years, but for heinous offenses it is 16 years. Now you will ask, what is a heinous offense? It depends upon the mode of commission of the crime and facts and circumstances of each case, which finally will be decided by the court. If the court finds that it was extremely brutal, in the mode of commission was extremely brutal, it may term that particular case or offense as a heinous offense and might treat a person as as an adult while taking up the age for juveniles as 16 years. Okay. Any question? while taking up the age for juveniles as 16 years. Okay. Any question? Synopsis is that Archit Rai is asking about how to make synopsis of the judgments. You simply do not have to cram or remember the facts of the case. No, that's not what you are supposed to do. Don't cram or don't rote the facts of the case. Simply find out the distinct or significant feature or a question of law decided by the court in every case. Make out a list of judgments which have decided some significant questions of law. That's it. For example, this Devilal's case is simply a case on determining the accused juvenility. So while making a list of the recent judgments, just write the name of the case and learn that in this case the Supreme Court decided this important question of law. That's it. Okay. Somesh is also asking, crime varies case to case and is subject to be decided by judiciary, right? Yes, absolutely right. Ankita, please ask me the questions I deal with. Don't ask me how many sessions will it take place, because these sessions will continue to take place unless any important topic is not left over. Okay. Okay, no doubts. I hope everyone is has understood. Are you sure things are clear to you? Okay, then I'm signing off. See you tomorrow, inshallah. Okay, then till then, bye bye.